Today we are going to be talking about Title IX. This presentation is from the Student, Family, and Community Services Department. Title IX of the Education Amendments Act of 1972 states, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any education program or activity receiving federal financial assistance." There are two objectives of Title IX. The Supreme Court has stated that these two objectives are to avoid the use of federal resources to support discriminatory practices and to provide individual citizens effective protection against those practices. There are three key inquiries that we are going to cover today in this Title IX training. Number one is what conduct is covered by Title IX. Number two, what triggers an institution's obligations to respond to an allegation of sexual harassment? And number three, what that response entails. Who is involved in the Title IX process? Everyone. Anyone within Plano ISD that hears or sees or witnesses anything like that, the whole staff is involved. What issues fall under Title IX? So we look at these and we say sex discrimination on the basis of sex. So every one of these can be completed with on the basis of sex. Gender-based discrimination, gender-based harassment, gender-based bullying, gender-based assault, sexual harassment, sexual assault, domestic violence, dating violence, stalking, and retaliation. Title IX also applies to the following issues impacting LGBTQ students: harassment based on sex or gender stereotypes or the student's perceived sexual orientation, sexual assault or sexual violence, failure to accommodate transgender students, and something that we are predicting may happen in the future is athletic participation for LGBTQ students. The old definition under the old Title IX rules described sexual harassment as unwelcome conduct of a sexual nature, which left it a bit wide open and hard to decipher. The new definition gives us a little more clarity. The new Title IX regulation provides for a narrower definition of sexual harassment that constitutes sex discrimination. The new definition has three types of sex-based conduct, which would constitute sexual harassment. Number one, sexual assault, dating violence, domestic violence, and stalking. Number two, unwelcome conduct that is so severe, pervasive, and objectively offensive that it effectively denies a person equal education access. And number three, an employee conditioning the aid, benefit, or service on participation of unwelcome sexual conduct. And that is your quid pro quo. A hostile environment, we consider several factors: the degree to which the conduct affected the student's education, the type, frequency, and duration of the conduct, the relationship between the victim and the participant, the number of individuals involved, the age and sex of the participants, the size of the school, location of incidents, and the context, and other incidents of sex-based harassment. Hostile environment must be based on sex. It must be severe and pervasive and objectively offensive. So when we look at severe, we look at the nature of the harassment, and we look at pervasive, the frequency of the harassment and length of time over which it has occurred, and we look at objectively offensive, a reasonable person standard. It must, again, to qualify for sexual harassment in a hostile environment, it must deprive of educational opportunities, and an isolated incident, if it is severe, can be sufficient. When we look at stalking, stalking is engaging in a course of conduct directed at a specific person that would cause a reasonable person to fear for his or her safety or the safety of others, or suffer substantial emotional distress. Stalking is covered by Title IX when the conduct is based on the complainant's sex. Domestic violence under Title IX is a felony or misdemeanor crime of violence committed by a current or former spouse or intimate partner of the complainant, a person with whom the complainant shares a child in common, a person who is cohabiting with or has cohabited with the complainant as a spouse or intimate partner, a person similarly situated to a spouse of the victim under the domestic or family violence laws of the jurisdiction receiving grant monies, or any other person against a complainant who is protected from that person's acts under the domestic or family violence laws of the jurisdiction. Dating violence under Title IX is violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. The existence of a relationship is determined based on a consideration of the length of the relationship, the type of relationship, and the frequency of interaction between the parties. Sexual harassment claims can be peer-to-peer sexual harassment or an employee sexually harassing a student. Sexual harassment can take place under any education program or activity. To trigger Title IX's protection, the harassment must occur within the school district's educational programs or activities on or off campus. This includes locations, events, or circumstances over which the recipient exercised substantial control over both the respondent and the context in which the sexual harassment occurs. And it must have been perpetrated against a person in the United States. Sexual harassment can take place, again, this is to qualify under Title IX. So sexual harassment can take place in the classroom, hallway, restroom, lunchroom, lockers, parking lot, on a computer, field trip, gym, playing field, bus, before or after school, or on a cell phone. What triggers a need to respond with a Title IX written notice? A district must respond when it has actual knowledge of sexual harassment and that occurred within the district's education program or activity and against a person in the United States. So all three of these have to be in place. Actual knowledge includes notice to any elementary or secondary school employee, and any person, for example, the alleged victim or any third party, may report to a Title IX coordinator in person or by email, phone, or mail. New regulations state that actual knowledge means notice of sexual harassment or allegations of sexual harassment by any employee of an elementary and secondary school. The OCR webinar on new Title IX regulations state in elementary and secondary schools, telling any school employee always puts the school on notice. Deliberate indifference. So after the new regulations, we anticipate that OCR will look at whether a school district has adopted policies and procedures consistent with the new regulations, employs a knowledgeable Title IX coordinator, and ensures the coordinator's name and contact information are on the school district's website and disseminated to all students, parents, and legal guardians, employees, applicants, etc. in handbooks, and notifies all individuals identified in the regulations of the Title IX formal complaint process, grievance process, investigation process, decision-making process, and appeals processes. We also must properly communicate with complainants and respondents regarding their rights and provide supportive measures as needed. We must train Title IX coordinators, investigators, and decision-makers as required by the new regulations, and those are separate in individual trainings based on those roles. We must train the school district personnel on identifying conduct prohibited by Title IX and applicable reporting procedures, which is what we are doing today. And we must regularly implement the policies and procedures adopted under the new regulations. Again, the definition includes under any education program or activity. An education program or activity includes situations over which the district exercises substantial control. Substantial control over activities includes field trips, academic conferences, or other school-sponsored travel, and it also applies to district-owned buildings. Some new terminology under the new Title IX rules. Complainant is the person alleged to be the victim of the sexual harassment. We entitle them complainant. Respondent is the person alleged to be the perpetrator of the sexual harassment. Again, we no longer use victim and perpetrator. We use complainant and respondent. A parent may act on behalf of a minor student who is a complainant or respondent. Schools must investigate allegations in any formal complaint and send written notice to both the complainant, respondent, and their parents of the allegations upon receipt of a former complaint. Written notice must inform both parties of the school's grievance process and include presumption of innocence at the onset of the grievance process. It must include key details of the allegations of sexual harassment, including parties involved, date and location of alleged incident, if known, and the alleged conduct that constitutes sexual harassment. The new regulations establish a first response protocol for Title IX coordinators. Specifically, if anyone reports sexual harassment, the Title IX coordinator must then promptly contact the complainant to confidentially discuss the availability of supportive measures, explain that supportive measures are available with or without filing of a formal complaint, and explain to the complainant the process for filing a formal complaint. A formal complaint is a document filed by the complainant or signed by the Title IX coordinator alleging sexual harassment against a respondent and requesting an investigation into the allegations. The investigation process includes 5 key roles. One is the Title IX coordinator, and this is the administrator designated as the Title IX coordinator to coordinate efforts to comply with the Title IX responsibilities. Number 2 is the informal resolution facilitator. This person serves neutrally and assists in the resolution. The investigator investigates and resolves complaints about sexual harassment or anything else that may fall under Title IX. The decision maker must objectively evaluate the evidence and reach a conclusion regarding the sexual harassment claims. And the appeals officer considers appeals requests narrowly, specific to the relevant criteria for appeal. Each role must include backups, because each campus should have backups at every level in case of conflict of interest. When we look at investigations, there are many things we have to consider. The burden of gathering evidence during the investigation remains on schools. Schools must provide equal opportunity for the parties to present facts, witnesses, and any other evidence. Schools cannot restrict the ability of the parties to discuss the allegations or gather evidence. Both parties must be allowed an opportunity to select an advisor who may be, but does not need to be, an attorney. Schools must send written notices of any investigative interviews, meetings, or hearings. Schools are required to disclose to the parties and their advisors any evidence directly related to the allegations and an investigative report that summarizes relevant evidence with at least 10 days for the parties to inspect, review, and respond. Schools cannot access any medical, psychological, or similar treatment records without written consent. The new Title IX legislation provides rape shield protections to complainants. All questions and evidence about a complainant's prior sexual behavior will be deemed irrelevant. It will only be allowed to prove that someone other than the respondent committed to the alleged misconduct, or it can be offered to prove consent. Mandatory dismissals happen when the claim does not meet the definition of sexual harassment, when the alleged sexual harassment did not occur in the district's education program or activity, or if the alleged sexual harassment did not occur in the United States of America. If it's dismissed from Title IX, the district can still investigate these claims under their code of conduct. Discretionary dismissals can happen if the complainant notifies the Title IX coordinator in writing that the complainant wishes to withdraw the formal complaint or some of its allegations, if the respondent is no longer employed by or enrolled in the district, and if there is a specific circumstance which prevents the district from gathering sufficient information in order to make a decision about the allegations. If you have any questions regarding Title IX with employees, you can contact June Melvin, Executive Director in Human Resources. If you have questions regarding Title IX and students, you can contact Dr. Jennifer Miley, Executive Director in Student, Family, and Community Services. If you have any questions regarding the Title IX training, you can contact Katie Flores, Coordinator, Student, Family, and Community Services. Thank you for your time.